we record the event. So we're going to record the event, so it'll be broadcast on and placed on YouTube afterwards. So hopefully, if anybody hasn't managed to join us today, you'll be able to share it with them afterwards. And then we're going to share Richard's screen and his presentation, which we will do now. And Richard, over to you.
Thanks very much, Stuart. Just to check that you can hear me okay.
Yep.
Yeah, excellent. And thank you also for picking out a repeatable quote that you found off the internet. It's always slightly unnerving when somebody starts off saying that. You think, what's coming next? But that's very kind of you. Good afternoon, everybody. I'm going to be relying on Stuart to flip through the presentation. I think Rory is one up on me because I think he's going to be in control of his slides. So Stuart, I'll just give you the nod. So if you can flick onto the first page, that would be great. Right.
It's all gone.
I think that must have been the final page.
Sorry.
So that's quite all right.
Try again. Yeah, I was at the end, not the beginning. That's no good at all.
Well, that's all right. Just while you're doing that, because the question I'm posing in my part of the event, and the idea is that both Rory and I can speak for about 15 minutes, and then we'll open it up for conversation, discussion, questions, etc. And so the question I'm posing is, Brexit, is this construction's greatest challenge? Bearing in mind that Rory is going to be speaking about COVID, I think that in itself could be a lively topic for debate. And it's clear that these are two of the major challenges that construction faces at this point in time. So yeah, Stuart, if you can just flick on to the next slide. Just by way of an overview, what I set out here, what I'm largely going to touch upon, and I've identified half a dozen areas where it strikes me construction has got some real challenges, hurdles, matters it has to consider in terms of how we're going to maintain business as usual. So just running through those quickly, obviously the labour market, workforce and skills, what's happening in relation to standards, product standards, especially regulations, other rules, what's happening in relation to movement and cost of both of materials and products, and obviously that does impact to an extent on the labour market as well. And of course we are still in the situation that we don't know whether or not there is going to be a deal, and everybody's anxiously holding their breath on that. I just wanted to mention red tape, more about that later, but in particular the question whether we can expect more or less red tape from the 1st of January onwards. And then just to finish off on a couple of specific elements, the first of which will be the question about extensive infrastructure investment and what the UK government is looking to do about that. And there are, of course, various competing factors there. And finally, I did just want to touch briefly on the question of planning and environmental law, and how and the degree to which that is likely to change. I think what we've seen certainly over the last 6 months is an increasing amount of action, noise, debate, discussion about the place that environmental considerations have, not just in relation to construction, but more broadly. And it's particularly entering the political sphere now. And what's that going to look like post Brexit? There you go, I'm not afraid to say it. And finally, I'll just spend a couple of minutes looking at how these risks are being dealt with, and some of the experiences that we're seeing, and I suspect they're common with what a lot of people are seeing in terms of treatment within negotiations and contract terms. Thanks, Stuart. On to the next. So the challenges. What's going to happen to the workforce and skills market? And this is arguably the biggest challenge that the construction sector had pre-Brexit, but of course in the sort of, I suppose, the lead up to the referendum, there was already a discussion and a debate going on about what was happening with the industry generally. the final point I've put on the slide there is a recommendation in relation to Mark Farmer's excellent report about Modernise or Die. Mark has, I suspect a number of people have heard and seen Mark speak, and he's posed some very interesting and challenging questions, some uncomfortable truths he's identified about what's happening with the industry, and whether it is it has the right demographic, whether there is good succession planning, is there enough diversity within the industry. Now, of course, with Brexit coming in, that adds a whole different aspect to it in terms of the degree to which the UK construction industry is reliant on migrant labour. As I say there, approximately 14% of the construction workforce are non-UK citizens. And there's a lot of discussion and debate about skills shortages and the pool of labour that we've got. So, and it's not just skilled labour, it's the need to have a balance between skilled and unskilled workforce to make sure that projects are running smoothly. It does obviously present an opportunity to change the demographics. Inevitably, as there will be with a number of these aspects, it's a question of looking into the crystal ball and seeing what seeing what the future will bring. But it's certainly my view, and of the view that has been expressed by a lot of commentators and people that we're talking to, that this is arguably the single greatest challenge. Thanks, Stuart. Next slide, please. Standards and regulations. Well, a lot of the discussion here is around the degree to which there's going to be some sort of uniformity of standards, particularly post-Brexit. And this isn't unique to construction. Obviously, we're seeing it in various other areas such as food standards. But there is still an open question about what's happening with the conformity assessed marking, the system that's going to come in to replace the EU requirements. A call has been put out to Alex Sharma by the Construction Leadership Council to ask that that there is a mutual recognition of standards to ensure that there is alignment with the EU. Whether or not that's going to happen, well, we hope that it will, because otherwise there is lots of potential for grey areas, dare I say, chaos in terms of whether we're going to be able to align the industry with what's happening in Europe and beyond. Obviously, the question of quality of materials and compliance with statutory requirements will still be very much part of the landscape, but these are elements that are going to come, if they're not already, it will be a very significant part of the landscape of negotiation, drafting of contracts, and ensuring that the risks are properly dealt with, to ensure that certainty of delivery of projects is what's going to be the future. Thanks, Stuart. Next slide. Related to that, obviously, is the question of movement and cost of materials and products, and what barriers are going to be put in the way. As I said earlier, we're waiting to see what's going to happen in terms of whether a deal is going to be reached, whether there is going to be alignment. If there isn't, and it's going to be a sort of, not necessarily a free-for-all, but we'll be into some significant rounds of trade talks and negotiations. Those will inevitably have an impact upon cost of materials, as well as free movement or relative free movement of labour. As I say there, the UK is a net importer. Approximately 22% of materials on construction projects come from outside the UK. That is a net figure rather than a gross figure. And of course, the impact this has is on the way in which smart procurement of supply chains has gone over the last few years. The notion of just-in-time supply to ensure that there's optimum efficiency in terms of getting materials to site, not stockpiling, what sort of approach our project team is going to have to take to ensure that they can plan for lead-in if there are going to be increased barriers after the end of December. Related to that, of course, is price certainty. And how that's it goes to the question of competitiveness of UK companies, and how this is going to be dealt with in not just in contract terms, but in terms of competitive procurement, which I'll just come on and talk about in a couple of minutes time. But ultimately, this is all going to come down to the question of what terms exist on negotiated trade deals that either happen within a structured deal with the EU or through rounds of successive trade talks and discussions once we formally come to the end of the transition period. Thanks, Stuart. So, big question. By leaving the EU, are we going to see the end of red tape, which was, and I want to try and stay out of politics in the remainder of the talk, but certainly one of the things that I think people were attracted to in the lead up to and execution of the referendum was whether we would be entering into a brave new world of reduced bureaucracy if we're outside the EU. Well, what's become clear is that there are going to be lots of new ties, new agreements, individual trade deals that are being negotiated, some of which have already come to fruition. I'm going to make a prediction. I don't think we are going to see less tape. I think we're going to see more, and that's regardless of whether or not there is going to be the conclusion of a deal with the EU. This is really a point in time. Trade discussions have been going on ever since we joined the EU. They've continued throughout. They will continue into the future. And it's going to require each and every business to be absolutely on its mettle to ensure that we understand what those look like and what the impacts are going to be in terms of how prices are going to be affected, what tax regimes are going to apply. So I'm afraid to say I can see that there will be increased bureaucracy as a result of this, and the notion of having control over what is happening post the 1st of January is well, let's see what happens. Thanks, Stuart. Next slide, please. So in the last few months, there has been lots of talk about what's happening with the construction sector and where's the growth going to come from, and particularly in the troubled times we're now experiencing. A great deal of emphasis on has understandably been on the investment that's going to be placed in infrastructure, particularly with things like high-speed rail, nuclear power. One of the effects of our leaving the EU is that there will be reduced access, obviously, to the investment bank and the investment fund. Everything will hinge on the government spending plans, and whilst the UK government will have autonomy over how it spends its money, it is open to question whether those funds are going to be compromised in some way, whether through international ties, whether through, I mean, we are in the midst of probably the most extraordinary round of spending and spending commitments that most of us will have seen ever. I don't want to sort of tread into territory that Rory's going to cover, but obviously with the Chancellor's plans, whilst we're in the situation that we are in, and whatever state of lockdown we've got, and the impact on the economy, that is clearly going to be a very major focus for government spending. I'd suggest that it's inevitably going to impact on certain projects. I know from personal experience that HS2 is ploughing ahead. if I could turn the camera around, I would be able to point you roughly in the direction of the midpoint. But and there is commitment there, but this is impacting on other projects, arguably things like Crossrail to the Western Rail link to Heathrow, and we remain to see how those projects, important projects, are going to play out. So again, I'm afraid the theme of this talk is largely watch this space, but that's like the world in which we're living. Thanks, Stuart. So finally, just to touch quickly on the question of planning and environmental, the regime that covers planning law and environmental assessments. And I've just put on the slide quite a useful link that people might want to follow, and I suspect when we've been involved in previous events, we've made the slides available, and I suspect that will be the case here. But it's worth having a look for anybody who is interested in what leaving the EU is going to mean for whether we're continuing to align environmental law, planning law to how things stood pre-Brexit. The message is very much that there's not going to be any substantive change of policy, and there is intention for smooth transition in various respects, but in particular for environmental impact assessments, etc. Obviously, the EU has been driving. It's one of the things that it's noted for is looking at the green agenda and ensuring sustainability. And there's often been discussion about the degree to which the UK is keeping pace with Europe and certain member states, and tracking ourselves alongside that. The intention that's set out there is a laudable one. Again, it remains to be seen whether that's going to be something that will the UK government will stick by. But apparently Boris is very keen on wind farms at the moment, so we'll wait and see how that plays out. Thanks, Stuart. So just in the final couple of minutes, I just want to touch upon how some of these aspects and risks are being dealt with and are likely to be dealt with within contracts and negotiations. I'm only going to sort of flip through this because I know that there's quite a degree of crossover here of some of the risks that are faced as a result of Brexit and as a result of what we're seeing with COVID-19. I know that Rory is going to talk in a bit more detail about some of these, but just to sort of give the headlines. Clearly, the impact that Brexit and other issues are going to have on the three main elements are going to be what it means for time, cost, and quality of projects, and certainty of delivery in ensuring that the client is going to get what it is bargaining for, and the contractors are able to make a sensible level of profit. There's an additional element which isn't on the slide, but it has come up in discussions and questions about contract terms that deal with changes in the law, which is provided for in all the standard contracts. That is going to be a very significant, we've seen that's a significant ground for discussion in terms of whether that is an uncertain element that contractors should be able to benefit from if there is a change in regulatory requirements or whatever regime applies, because it's an additional cost that is outside their control, and they shouldn't be able to, they shouldn't be at risk on it. Essentially, we're seeing things from various different angles. Clients are taking steps to risk-proof contracts as far as possible. Contractors are doing likewise, and the insurance market is hardening its stance in this respect. So there's no single argument that's a killer on this. It really comes down to a question of what the relationships are that exist between the negotiating parties, and what view they're prepared to take on the question of risk and how it's dealt with. I've just mentioned at the bottom there, because this specifically came out of the event that Stuart talked about, in terms of whether there are you know, there are challenges to performance and lack of resource, etc. And I just posed that point in terms of saying that there is an absence of capacity in some respects, but that may mean that there is quite a lot of opportunity out there. And I'd always like to sort of try and end on a high note. Stuart, there's just a couple to sort of flick through. I'll just post the question on the next one about will risk be allocated or shared. I touched on that. You know, JCT is a risk allocation philosophy in general terms. NEC is the sharing of risk. I think we're going to see quite a sort of mash up between those two different approaches. And the final slide, I say I want to leave on some good news. There was indication over the summer that activity was up. This is just quite an interesting illustration, because where most of the activity seems to be is in the housing sectors, as might be expected. The jury's out, of course, on commercial build and speculative build, but the housing market is going to remain buoyant. That's not going to be affected by Brexit. And I think it will remain strong, and other factors will impact on that to shift the dynamics on it. So that's where I'm going to leave it for the time being, but I'll be very happy to take questions when we come back to that section. Thanks.
Okay, thank you very much, Richard. So we come to the end of this section, and I will allow Rory to take over and take the stage. So Rory, if you'd like to share your screen. And the other thing I should say, yeah, there's some Q&A coming through, so there is a question and answer box if people do want to add in their questions as we go through, and we'll take the questions at the end. So Rory has shared his screen, and if that's all okay, I will let you take it away. Thank you, Rory.
Excellent. Thank you very much for the introduction, Stuart, and thank you, Richard, for your talk there. As Richard mentioned, I'm going to touch upon some aspects of the Brexit related issues, and that will cross over with COVID to an extent. So as mentioned, my name is Rory Abel. I'm a senior associate in the construction team at Birketts. Today I'm going to focus on the construction, the impact on construction that is being felt by COVID. And basically it's split down into three parts, my discussion today. So the first my first part is going to be me mentioning very briefly what COVID is, for those of you who may have been under a rock for the last year. The second part is going to focus on JCT and NEC forms of contract and how they're dealing with COVID, particularly focusing on time and money related claims, and that's for existing and for future contracts. And then just to round off, I'm going to provide a bit of experience on a practical level as to how people are approaching COVID-19 and its impact on construction contracts that we've noticed. So to start then, I'm sure that many of you will have seen the announcements over the weekend about a second lockdown, which is going to become effective from tomorrow. I'm sure that many of you who have got a keen eye will have seen that my talk was actually prepared before that announcement. So just to recap, in response to what is a severe respiratory syndrome, the UK government has introduced in March 2020 a national lockdown. And then subsequently what it introduced was a three-tiered system, which is now replaced by a second national lockdown. It's important to note at this stage that actually the UK as a whole hasn't taken a consistent approach to this virus. So Scotland and Wales have taken very different approaches to England in this respect. So when you're looking at your contracts, you need to be careful to make sure that you are assessing the position based on what's happening on the actual site location. Also, we've noted, and it was mentioned by Richard, that the Construction Leadership Council have been very active throughout this issue, and they did issue a note on the 2nd of November to confirm that they weren't anticipating there being any changes to the current guidance in relation to how construction sites should operate. And so it's expected really that construction should hopefully be relatively unaffected by this second lockdown, but the exact implications obviously remain to be seen. So moving on then to take a look at contractual approaches. And as I say, I want to focus really here on what are the time and money implications for COVID related issues. We'll take a look at existing and future contracts. But before we do that, I just want to emphasise, and a real key takeaway from today is the fact that whilst we are in exceptional times and no one's debating that, contractual principles remain the same. So just because of the current crisis, you still need to follow the basic contractual principles. And just to sort of recap, really, you must be making sure that you're reading your contract. So make sure you're familiar with the terms of your contract. Make sure that you're getting in the right notices that you need to send in accordance with the contracts in order to enable you to claim time and money. And make sure that you're keeping thorough records. Contemporaneous evidence is crucial when you're assessing time and money related claims. So today, as I said, we're going to talk about JCT and NEC forms of contract. The way the talk is structured is that it focuses on the unamended forms. I think most people presumably in the audience will be familiar with the fact that a lot of lawyers do amend those contracts. So you need to be careful not to take me at my word. You must read your own contract to make sure that these principles apply. So let's start with JCT then. For those of you who are not aware, JCT takes an approach of separating out time and money related claims. So we have to take a look at each one in turn. So under the JCT forms of contract, we have to consider when we're talking about time as to whether COVID could be considered what's called a relevant event. And if it is considered a relevant event, then there's a chance the contractor will have the entitlement to claim additional time. Under the JCT forms of contract, there are a few potential relevant events which may apply in this COVID scenario. One of which is impediment by the employer, the second of which is an exercise by the UK government of their statutory power, and the final one is potentially force majeure. Due to the time restrictions today, I can't talk about each one in turn. So what I'm going to do is just focus on force majeure for the purposes of today's talk. For those of you who aren't aware, force majeure is actually a French term, which when translated literally means superior force. Unfortunately for us, it's undefined in the JCT forms of contract. So you won't find any specific definition in which clarifies the scope of force majeure. So what we have to do is look to case law basically to give us an indication as to what force majeure means in the context of construction. And whilst it's not 100% clear, the case of Labuben against Crispin does provide us with some indication as to what might be considered force majeure. So in that case, it was said that all the circumstances independent of the will of man, and which it is not in his power to control, thus war, inundations, and epidemics are causes of force majeure. So whilst that case doesn't specifically refer to COVID-19, and we haven't had any case law as yet to clarify that, it does produce some persuasive evidence that force majeure could potentially include COVID-19. Now we'll come on to in a second the fact that whilst it may be the case that force majeure includes COVID-19, there are other hurdles that contractors have to overcome in order to be successful in a claim for additional time. Before I do that, though, I want to emphasise that JCT forms of contract do not require the contractor to prove that the loss was unforeseeable. So there is no foreseeability criteria under the JCT forms of contracts. What that means is that even if you entered into a contract after March 2020, you are probably still able to classify COVID-19 as a force majeure event, and the fact that it was foreseen at that time won't make any difference. It may be the case that that's different in the NEC forms of contract, which we'll come on to talk about in a bit more detail shortly. Also, just wanted to mention briefly that I said that time and money is dealt with separately in the JCT forms of contract. In relation to money, there is no what's called a relevant matter, which covers force majeure events. And so it's unlikely that contractors are going to have the ability to claim money in relation to COVID-19, as there are no obvious headings that they can point to. So the other difficulties that contractors have when they're trying to establish an extension of time claim under the JCT forms of contract is that they have to prove that the force majeure event actually caused the delay. And it's this causation element that can sometimes be very difficult to prove. And it's why at the beginning of this talk, I mentioned about the fact that record keeping is crucial, because that record keeping and those records are going to need to be referred to in any claim for an extension of time by the contractor. So contractors need to be very careful about making sure that any claims they're putting in are well supported and properly worded to ensure the best chance of succeeding. Another thing that contractors need to consider is the fact that they always are under an obligation to mitigate their losses, and they have to exercise what's known as their best endeavours in order to enable them to claim additional time. What we mean by best endeavours is set out in case law, which says it's taking steps that are prudent, determined, and which a reasonable person acting in his own best interests and desiring to achieve the result would have taken. Keating on construction contracts actually deals with this point and mentions the fact that what that's likely to mean in practice is that you actually probably have to reprogram, and you potentially have to expend substantial sums of money in order to minimise your delay. What's meant by substantial and what extent reprogramming is necessary will depend on the exact circumstances, and so it has to be considered on a case-by-case basis, unfortunately. So when we're looking at future contracts then, so future JCT contracts, for those of you who may be considering entering into them shortly, what you need to consider is the fact that the JCT themselves haven't produced any amendments, but the CLC have produced amendments for 3 separate options. So they're outlined on the slide as being time and no money, time and money, and time and a percentage of money. And what I would say at this stage is that whilst I can appreciate it's very difficult to have conversations on allocating risk at the outset of a project, I think it's in both parties' interests to have very open discussions about COVID-19 and how you are going to deal with time and money under your contracts, and basically ensuring that any contracts that are put in place do properly reflect the risk allocation. It's not in either party's interest not to clarify that, because all that will happen is that a dispute or disagreement may arise at a later point, which then takes time and money to resolve. So looking then at the CLC forms of amendments that have been produced, this is the time and money example, and what I wanted to do was just highlight a few points that are worth noting on these forms of contract. So the first of which is the fact that under point I under the amendment, there is coverage for COVID-19, but also any mutations. So we have to accept that COVID-19 is potentially a disease that will mutate, and so we have to allow for that in the drafting. Secondly, there is broader guidance here, broader considerations here to cover recommendations and guidance which have been issued by the government, so not just changes in law. And finally, I wanted to note that there are also coverages for restrictions on site access, as well as shortages of labour and materials. So it's not just access which is covered, but also if it's having an impact on your ability to get labour and materials. So generally speaking, this is quite a broad clause. What we're seeing in practice is more restrictive drafting around COVID-19, so that it's not quite as wide as this. But what you're putting in place will depend entirely on the particular contract you're negotiating. So moving on to NEC, then NEC forms of contract adopt a very similar approach to JCT, but it is slightly different. One obvious difference is the fact that under NEC forms of contract, they deal with time and money as a whole. It's not separated out as it is in the JCT forms. And what you have to consider when you're looking at JCT forms is whether COVID could amount to a compensation event. So on the slide, we've highlighted one of the compensation events which is most likely to apply in a COVID scenario. It does operate in a similar way to the force majeure provisions in the JCT forms of contract, but there is one key difference, and that is the foreseeability issue, which we said didn't apply for JCT contracts. It does when you come to NEC forms. And the wording that you have to consider is whether an experienced contractor would have judged the event with having such a small chance of occurring at the point of entering into the contract that it would have been unreasonable to have allowed for it. So for those of you who've entered into NEC forms of contract after March 2020, there is a real risk that you will not be able to fulfill that foreseeability criteria and therefore not be able to claim a compensation event. For those that are entered into pre-March 2020, I think that depending on how far before March 2020 they were entered into, increases your chances of being able to successfully claim time and money. On the slide I've set out there an example of the CLC's amendments to the NEC form of contract, which allow for time and no money. These are broadly in line with what we've seen in the JCT set of amendments. So they have similar scope in terms of covering off variations, including guidance that's issued by the government and not just changes in law, and also covering for shortages of labour and materials. So to round off my part of the talk, I'm just going to briefly have a look at the practical approach that people are taking in the construction sector. In relation to existing projects, what we're finding is that employers have generally been sympathetic on time. So they've often tried to allow contractors the ability to claim additional time, but not necessarily in relation to money. So depending on what form of contract it is and what the exact amendments may be to that contract, that's the general approach we've seen. And what it's important to note for the contractors in the room is that actually you have to consider that whilst the employer may be reasonable, he may often be tied into third-party agreements, such as funding agreements or agreements for lease, which do inhibit his ability to act reasonably and require that third party to be on the same page as him in terms of approach. At this stage, it's a bit too early to say what the adjudicators and courts are going to do in relation to interpreting contractual provisions in the context of COVID. What we do expect to see is an increased activity in this area over the coming months, especially as a lot of contracts that were entered into before COVID will be coming up to practical completion, and final account discussions will then start to ramp up, and that's likely to lead to increased litigation in this area. On new projects, again, we've seen a very mixed picture. Richard talked earlier about bargaining position of the party, and I think that's exactly right. I think that the bargaining position between the parties is having a real impact on what's being agreed in terms of risk allocation. I think that employers generally seem to be comfortable talking about time and allowing time to contractors, but certainly when it comes to money, they're expecting contractors to take the risk in that area. I just wanted to mention briefly the procurement policy note 02020 and 0420. So this applies to those who are acting for public sector clients. So it's a procurement note which was issued and has actually come to an end now at the end of October, but it was trying to encourage public sector bodies to act collaboratively with their suppliers in order to establish sustainable contracts moving forward. We've noticed a lot of activity in this area, and so I'm hoping that those who are working with public sector bodies have found that that conversation has flowed through to try and establish a regime to move forward in a sustainable way on your existing contracts. So finally then, just to round off where we've got to, under standard form contracts, and a point that was echoed really by Richard, is that I think they do present opportunities to contractors to formulate certainly time-related claims and possibly money claims as well. But unfortunately, whilst there is opportunity, I think there still is a lot of uncertainty around exactly what the scope is. And so that's something that contractors and employers just will have to deal with for the time being. What I would say and what I would re-emphasise is that for those future contracts, you must be having conversations about how you're going to allocate risk and ensure that it's properly drafted. On the slide, what I've done is highlighted 4 things that you should consider when you're entering into future contracts. So the first of these is to make sure that you're covering any variations or mutations to COVID-19 as a disease, so that it gives a broad coverage. Secondly, you'll want to clarify whether or not the contractor is entitled to claim for shortages of labour and or materials, and also whether or not government guidance is going to be considered when assessing a time and money related claim. To end, I just want to say that subcontractors and main contractors who may be presented with slightly narrower definitions and drafting around COVID-19 should just make sure that those are being reviewed correctly to make sure that the coverage is what you're expecting, so that you have some flexibility to claim time and or money if possible. That brings to an end my part of slide. I'm just going to end my slideshow and stop sharing my screen.
Brilliant.
There we go.
Thank you, Rory. Thank you. We've just got a few questions, and there's quite a few that come in. I think one of us is your volume a little bit loud. I don't know if you can perhaps drop your volume down a little bit or something. There's a little bit of feedback, I think, but other than that, all is good. So Richard, I think there's a few questions come in online, and there's a few questions that we had before the event. So if we perhaps start with a question from Jenny, which is quite good. Are there any trends on Brexit indicating typical stances from clients when drafting contracts?
I suppose trends, not really. It's very much a case of it. It kind of depends. There's a slightly sectoral approach to this, and it largely depends upon, I suppose, type of project where the supply lines exist, and really, and it's very interesting. Hearing Rory talking about the various areas in which the contracts are being amended and the sorts of things that that clients in particular are looking at. I think what we saw with Brexit pre-COVID, and it's sort of a trend that has continued over the last few months, but they've kind of merged into a broader area. It was quite a there were some quite narrow provisions that were being looked at, primarily looking at the question of availability of materials, whether that was going to impact upon time for performance, whether programs were going to be adversely affected, particularly if certain types of goods were essential to a particular project or a supply line. I think I'd be interested what Rory's experience has been on this, but ours was that yes, we did see certain clients in certain sectors, usually where interestingly we saw some coming in relation to provision of specific specific types of slating material coming from the continent, and you had employers who were taking a very sort of clear view on what they needed to do to ensure their supply lines could be honoured. I think in the main, though, the majority of contracts tended not to be hugely affected by Brexit clauses. What we did see was that I suppose it was more driven from the contractor side. Contractors were looking to sort of build in a bit of margin and flex, because of the sort of the uncertainty of what the future might bring, to ensure that there was as much scope for them to be able to cover off that risk if there was a problem, not necessarily in their tier one supply, but possibly further down the line. It's the sort of the known unknowns, if you like. But we haven't seen great swathes of redrafting of contracts, bringing in Brexit and Brexit-related clauses, and I suspect a lot of that is now backed into what we're seeing on COVID.
Yeah, I think just picking up on that, Richard, I think I share your experiences in that Brexit's obviously been something that's been on the cards for a very long period of time. And I think a year ago we did a talk on Brexit, and just before that we were seeing a lot more amendments being put forward, primarily by contractors. It's all contractor driven because of the way the contracts are drafted at the moment. They often push any risk that could arise onto contractors. It's definitely contractors who are putting those forward. But miraculously, since COVID's become an issue, I've not seen a single Brexit-related amendment being put forward by a contractor, and it just shows, I think, that people's attention and focus has definitely shifted. And the issue that we were finding with anything that was put forward on the Brexit front is that they're very difficult to draft because the potential outcomes are very uncertain, and no one in the construction supply chain really knows where the risks are going to come. So what we did see is some contractors putting forward alternatives to allow them flexibility on choice of materials if there are some unavailability. But from a client perspective, they're always looking to control the final project and what the outcome is.
Were you ever seeing, sorry to sort of jump in, I'm stealing Stuart's prerogative here, but were you ever seeing sort of preemptive strikes? And are you seeing preemptive strikes where you've got a client who is perhaps trying to take a risk out of the realm? I mean, I think I don't recall having seen this in relation to Brexit, but we're certainly getting it in some instances in relation to COVID to say, well, you definitely can't claim for anything that is COVID related.
Yeah, I think that sort of touches upon my point really about having those conversations at the outset. And whilst it just adds another point into the mix, I think it's much better for the parties to have those discussions and thrash out where the boundaries lie so that the drafting can properly reflect that. And I think everyone's very much aware of what's going on and what the impacts are. And so all contractors at all levels really are having those conversations, I think, with their clients. Which is right, because it just creates a bit more certainty in the drafting and allows those issues to be considered up front, basically.
Good stuff. Okay. If we take Jenny's question and kind of merge it in with one that we've had before as well, I think, that question about clients' views hardening on COVID, particularly when it comes to drafting contracts, and how do you see, Rory, future projects dealing with the risk of COVID now that it's no longer regarded as force majeure, or it certainly isn't anymore?
Yeah, well, certainly form of contract is key when we're considering whether or not something is or isn't force majeure. And I pointed it out in my talk that under the JCT forms of contract, because you don't have this requirement of foreseeability, arguably COVID-19 can still be considered force majeure even now, and for contracts entered into after March. I think what we're possibly going to see in relation to the NEC forms of contract is I think we'll see contractors wanting to remove that foreseeability criteria. I think that's something that will be put forward, and we are seeing that requested. And under the JCT forms of contract, I think that you may see contractors asking for fluctuation provisions to be included, which in my view historically have been something that's not included and allowed for. But it comes back to bargaining position of the parties and how the employer's positioned as well. Under separate third-party agreements that may already have been entered into, there may not be that flexibility to allow for time and or money to a contractor. And so I think that it depends upon the bargaining position. But certainly time seems to be one where employers are taking a slightly more relaxed view.
Is that the same? Do you get the same view?
Yeah, it's interesting because we've all learned quite a lot in the last 9 months or so, and the flurry of activity I think that we all saw back in the spring was because this was new territory. It isn't new territory anymore. It's something that the whole question, as Rory says, the whole question of whether force majeure is going to come into play it's a question of, look, if it's outside of the party's control and it couldn't have been foreseen, then there's a route by which you can see claims being made out. But particularly now for contracts that are being entered into, it's almost I don't know about you, Rory, but it's almost the first question that's being asked about is, well, how do we deal with risks that flow out of COVID? It's a similar thing with Brexit, and we're, as Rory says, we're even further down the line on that front. But I think it's part of the regular agenda for discussion, in the same way that, for example, who takes the risk for ground conditions are.
Yeah, I think that one thing I didn't mention is that under the JCT forms of contract, I said obviously that force majeure is undefined, and certainly one of the to be perfectly honest with you, within our amendments, we would always define force majeure anyway before COVID. But certainly, I suspect that many contractors and clients will be looking to do that in the future anyway, just to establish scope and avoid any uncertainty that we've felt so far on unamended forms of contract around that definition.
Yeah, I agree with that.
Okay, and there's a question that's come in from David Evans, who we all know well.
Oh no, not David. he always asks the most tricky ones.
An interesting point. Would designers be well advised to specify that products and materials comply both with EU standards and UK standards, whatever they may be, rather than opt for just UK standards, just to avoid any issues of professional negligence?
That's a question I could have easily anticipated, because I know this is something that David and I have discussed in the past. And in terms of whether it was good practice, I think going back several years, and the contract terms were always, do you specify materials to comply with British standards, and then it moved over to Euro codes and EU standards and requirements. I think the best way I can answer it at the moment is because there is still a degree of uncertainty about what's going to happen with the UKCA regime and whether that's going to tie in. I think that the approach that the CLC has taken, and they're, as I understand it, they're still awaiting a response from Alok Sharma on this, is that they're asking for uniformity and for the standards to be aligned. I think until we've got that certainty or clarity on that position, that would probably be a sensible way of going about it. And I suspect it may be a case of, well, again, it comes down to the dynamics of discussion between client and contractor, is whether you say that we've got the two standards and it will be the most stringent of whichever standard applies in each respective case. But it doesn't make for a great deal of clarity at the moment.
And I think that's, you mentioned about contractors there, but I'm seeing that also from consultants and their insurers, in that they are looking at these prohibited materials clauses as, a lot more closely than maybe they were before, and where you might typically see reference to the EU, that some are taking the approach to remove those references. I think that, insurance market, and I know you mentioned in your talk, Richard, about the fact that insurance sector is getting more tricky and hardening. And I think that that's something that's really being felt. Not only is it a tough market in terms of contractors, consultants getting, reasonable premiums, the actual terms on which insurers are willing to operate is getting a lot tougher as well. And we're seeing that there's a lot more time spent negotiating with insurers than there has been necessarily in the past. So yeah, it's a really interesting point.
There's another question has come in live, which is quite interesting. Might a deed of variation to deal with COVID-19 under JCT contracts provisions achieve better reciprocity on this one? Is that something, Rory, that you'd be able to comment on?
So I think what the question's saying is, for those existing contracts where you've not got clarity around force majeure, for example, or whether or not there's an intention that the contractor would be entitled to anything, whether that be time and or money in relation to COVID, then a deed of variation, I think certainly is probably going to be necessary to establish that. Whether the clients have the appetite to agree to a deed of variation in that context, I suspect the answer might be that they may well sit back and let the contractor put up a fight to clarify whether or not something is going to give them an entitlement to time or money, because depending on the form of contract, clients often find themselves sitting in a relatively comfortable position. But yeah, certainly a deed of variation is something that should be considered to clarify any agreement which has been reached. And it's something that's come up on other projects where you have gentlemen's agreements, for example, about how you're going to deal with any delay, so the lockdown period, whether you agree that will be an EOT. Anything that you agree with between the parties should be captured to properly reflect the terms and make amendments to the existing contract as you need to. And a deed of variation is the most robust vehicle to do that in most cases.
Great stuff. I think there's there's maybe two final questions I'll just squeeze in if we can before the end and we reach our hour. Firstly, following on what we've just said, there's an interesting question from that's arrived earlier, which says, what does best endeavours, or what does the best endeavours obligation under JCT require a contractor to do? Would it have to continue to perform work, albeit with reduced operatives?
Yeah, so picking up on that one, I think that, best endeavours obligations is something which I mentioned in my talk, and is a requirement on all those who've entered into JCT contracts. Whether it would require them to act with reduced operatives, I think the answer is probably would. You have to consider whether or not those steps are what a prudent, determined and reasonable owner would take when they're trying to achieve their own outcomes. And it's certainly something which is more onerous than reasonable endeavours, which you might see in some contracts. Keating on construction contracts, as I said in my talk, talked about the fact that you're probably going to have to reprogram as a contractor, and you're possibly going to have to expend substantial sums of money. The exact scope of that is to be determined on a case-by-case basis, and we don't really know what the courts are going to say in relation to that. But I think certainly a good point to note is when we had the first lockdown, what you saw from a lot of contractors was a complete shutting down of sites, and a pause on work completely. I think that was probably could be argued to be reasonable in some respects, in that they had to carry out their own risk assessments and establish how they could operate, given the current climate. I don't think that would necessarily be the same when we go into our second lockdown tomorrow. I know there's a lot more certainty now about construction operations continuing, but any contractor who looks to close their site entirely without any justification is, I think, going to be in a very difficult position, because I think that there would be an expectation that you have already established how you work in the current climate, and so I don't see the need for contractors to close entirely.
Great. And then just finally, Richard, this is quite an interesting one. Are the rumours of a construction of a huge lorry park and border controls on the Kent border exaggerated?
Given that I think that rumour initially started with a statement from Michael Gove, I don't think it probably is, but it's a really interesting point, and it goes to a whole host of things, not least of which are quite emotive, because it's that broader picture of what Brexit is all about. But I think it underlines the very specific point about certainty of delivery of, whether it's goods, materials, performance generally, particularly where we're looking at just in time supply chains. And I think the sort of Rory touched upon whether delay analysts are going to be very busy in the coming years. I think it's something for project managers to be very much on top of, and to be looking to build into project programs in terms of planning for possibly for longer lead-in times. We don't know if there is going to be a big stacking up, whether in Kent or wherever. But it has to be a very real possibility. Watch this space.
Great stuff. Okay, thank you all very much. Thank you all for attending. We've got a few things coming up in the next few weeks. So there's a networking breakfast for Constructing Excellence Cambridge and Oxford next week on the 11th of November. I know the Oxford group have other webinars, including one on bidding to win with a bidding expert. And then we have a webinar, if you can't get enough of law and the legal stuff, then we have another legal thing coming up on, I think it's the 18th of November. Check the Constructing Excellence Cambridge Oxford website for the details of that, but that will be looking specifically at disputes and how to deal with them, again, in the new normal, in the current situation in which we find ourselves. So thank you all very much for attending. Thank you to Richard and to Rory for their contributions, their speaking today, and we'll hopefully see you all again soon. Thank you.
Thanks very much.
Thanks, Stuart.